Okay, hello everybody and welcome to today's webinar, Law-Informed Research, Intake and Triage and the Value of Telephone Legal Information Services to Clients. My name is Sam Cooper. I am a Sector Sustainability Coordinator at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land which we are holding this webinar today. In Brisbane, they're the Turrbal and the Yuggera people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders play and continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Nations Australians listening today. So we're joined by Karen and Katrina. As part of the Community Legal Centres Demand Management Project, we have reached out to them for their expertise in these areas. This webinar has been done in partnership with the Law and Justice Foundation and will provide insight into developing a triage framework, referral pathways and the value of information services to clients. We will be drawing on their work undertaken under research alliances with New South Wales Legal Aid and Victoria Legal Aid. I will leave it over to both of these lovely women who are very kindly donating their time and expertise to let you know a little bit more about themselves when I hand over in a moment. Today's webinar is being recorded and we'll have the recording available to download later on today or tomorrow. The PowerPoints and other materials have been emailed out to everybody. I think there might have been a bit of an issue with the email, so I apologise for that. But they are also available on the website to download and from the handout section of the GoToWebinar control panel. If you haven't got them, they will also be viewed on the screen. There are two ways that you can ask questions. You can press the button that looks like a hand that we've all just been practicing. Thank you so much. We'll see your hand go up at our end and we can unmute you so you can ask your questions. Alternatively, you can type them into the question box and we will be addressing these at the end of the presentation. Feel free to type them in as you think of them, though. We don't expect you to hold them. I'll now hand over to the lovely women from the Law and Justice Foundation. Karen will be first, and I'll talk to you again at the end of the session. Thank you so much.
Thank you so much, Sam. Good afternoon, everybody. The work that I'm going to present today is based on a project the Foundation undertook with Legal Aid New South Wales under our Research Alliance. Today, however, we'll be looking at this topic with a more inclusive view that's more relevant to legal assistance providers broadly, not just legal aid. The publication is available on the Foundation website if you'd like to read more. It's called Developing a Triage Framework, Linking Clients with Services at Legal Aid New South Wales, and was written by Christine Comarolis and Hugh McDonald, and I'd like to give credit to them for the earlier work that this presentation builds on. Okay, so this afternoon we'll briefly look at what triage is, what are some of the approaches to triage, and how you might go about developing a triage model for your service. The definition of triage is the sorting of and allocation of treatment to patients according to a system of priorities designed to maximise the number of survivors. It is the sorting of patients according to the urgency of their need for care. The Cambridge Dictionary also defines triage as the process of examining problems in order to decide which ones are the most serious and must be dealt with first. Triage also takes into account the urgency, severity and complexity of the problem. For instance, urgent legal problems might include instances where a legal process or consequence is imminent or where the client is in crisis. So imminent legal problems may be a court appearance, deportation, mortgage default or repossession, or risk of a child being taken out of jurisdiction. The urgency is used to determine the speed of the intervention that's necessary to achieve an optimal outcome. So urgency is independent of severity and complexity. It's also worth noting here that triage is often not a one-time event, it's a dynamic state. So if circumstances change or more information becomes available, re-triage must occur. The other thing to note here is that you're already doing triage in one form or another, even if it's not called triage or if there is no formalised process. So triage happens at all levels. So we have system level triage, which we're not going to go into detail in this presentation today, but that refers to the triage that happens at a sector-wide level. So it refers to mechanisms that direct or sort people towards different types of legal assistance. Organisational level triage, this is sometimes also referred to as provider level. This can occur through service initiatives. For example, it's well recognised that those clients who are able to contact a legal service looking for help are fundamentally different from those who do not contact a service looking for help. In other words, how hard a legal service is to find determines the kinds of clients who will find it. So service initiatives such as outreach services aim to take the service to the client rather than the client having to find the service. This is particularly important for certain demographic groups, typically those with a lower level of legal capability or who otherwise face barriers to accessing mainstream legal assistance services. Other examples of organisational level triage would include the allocation of greater resources to certain types of legal problems, such as crime matters over civil matters maybe, or duty lawyer services in local or family courts to target clients based on a legal problem type. Individual level triage refers to the criteria that's used to select or prioritise clients for assistance within a particular intake stream or service. So for some services, such as outreach or duty lawyer services, triage occurs at both the organisational level and the individual level. Because although these services, by their very nature and location, are already targeting certain types of client and legal problems, clients who then access these services will be further triaged to match the client with the appropriate level and type of assistance. There's a variety of principles or approaches to triage that are useful, and many of these are founded on bioethics principles, but they're relevant for legal services. The approaches that are chosen are often dictated by the mission or the aim of the service or the organisation, but most commonly a combination of approaches are used. So we're going to briefly look at some of these approaches. The first is first come, first served, which is just providing the service to those who come through the door. The risk of this approach is that it may favour potential clients that are more capable or persistent rather than the most in need or the least capable. So an example could be some advice lines or legal advice clinics, and it's often used in the allocation of clients within some outreach settings. The next approach is the equal chance of receiving service, or the lottery approach. This approach is not often used outside of research settings or trials, and it's generally used in order to create the equivalent of a randomised trial. Weighting can be added to particular groups if necessary. And this approach can sometimes be useful when other more nuanced or just ways of triaging are impracticable, or after other approaches have already been applied and there's still more equally situated claimants than resources can accommodate. The next way is priority to the worst off in terms of legal need, assisting those likely to have the worst legal outcomes if not assisted. There is a risk that those with more may have more to lose, and therefore can sometimes preference wealthier or better off clients above those who have less. So there's a need to factor in client resources and capability into this approach. And this can be done by considering who has less chance of getting alternative help or a good outcome without your assistance. An example of this kind of approach is in the allocation of some grants and some targeted outreach services. The next approach is the priority based on urgency. This is your standard emergency room model. So it preferences those that are in urgent need at the time of allocation over those who may be worse off over a lifetime. So duty lawyer services are going to consider urgency over severity. The next approach is best outcome or longer term outcomes. This approach is a forward-looking approach that looks at how much an individual will gain or avoid losing compared with other possible claimants. It depends both on the expected value of the outcome and how likely those outcomes are to occur. So when considering longer term outcomes, age weighting will preference younger people over older people, as the intervention may have a longer effect. And the impact of the outcome on young people may be greater. So examples of special provisions for young people or young people as a priority group. And then the last approach is assisting the most people. So this is allocating resources to the cause that will benefit the most people rather than to a cause that benefits only an individual. So in a world of finite resources, this can sometimes be helping a large number of people a little bit or helping a few people a lot. So developing a triage model requires consideration of a number of factors and how they relate to each other. So here are a few for you to consider. They're not in any particular order. So the aims of triage for a specific service will depend on the broad principles and goals of the organisation, as well as the more specific aims and goals of the particular services that are delivered. For instance, the aims, vision, purpose, they will guide the basis for determining its client pool, with some organisations providing services to the broader community and others providing services for more specific target groups. So you see that in generalist services and specialist services. So the triage principles chosen may depend on the organisation's mission statement, their vision, their strategic framework priorities, legislative mandate and scope, governance or their board, funding requirements, etc. All of these things are part of considering into your triage model. The type and role of triage will also vary by intake mode or pathway. So for example, legal advice telephone lines and legal advice clinics, outreach clinics and duty lawyer services, they're all likely to vary in terms of the mix of clients and their legal capability, in terms of urgency of issues and type of need. So some intake pathways may be open to the broad community, like telephone advice lines, while others will be only open to a specific target group. Organisations may decide that those with higher legal capability should perhaps be filtered out at this stage or linked with external assistance. The next thing we want to consider is client characteristics, and these include specific disadvantaged groups that can be targeted by service initiatives, such as people experiencing homelessness or migrants. And these client groups can face particular types of complex problems and may experience heightened forms of disadvantage. Legal capability of clients refers to the personal characteristics or competencies that are needed to effectively resolve legal problems. These competencies might include knowledge, skills, psychological readiness, and other resources. A relevant triage question would therefore be, how likely is this person to be able to resolve the problem without assistance, or without assistance to a certain level? And to answer this question, it can be useful to know how long this person has had this problem. Relevant criteria for triage may also vary by area of law: criminal, civil, family, and the type of action, so litigation compared to transactional legal services. Some areas or actions have greater potential than others for self-help or unbundled service provisions. Legal assistance services are often targeted to different types of legal problems. And relevant triage questions here may be, is the presenting legal problem one for which the service can provide assistance? How much assistance is required to progress or resolve the problem? And does the service have the capacity to provide assistance in the given circumstances? Remembering that legal problems also vary according to their urgency and severity, and these are also key criteria for triage. Knowing what services are available is fundamental. So the general purpose of triage is to link clients with relevant services. Triage questions here concern what type of assistance is appropriate and whether there is capacity to deliver that assistance. For instance, can the triage officer assist directly with the presenting problem, and especially if the triage is undertaken by a lawyer? Is another service provider more appropriate? Available service options will vary by the capacity of the service provider, the timing and urgency of the issues, the geographic location of the client, and the capability of the client to make effective use of a particular service or assistance option. If the legal service provider cannot assist with the problem, then the client will have to be triaged out, irrespective of their legal need or capability. And this is where it's really important to keep up to date with what other services are providing. Another key triage question is who will get the most out of the assistance provided? And this is where we consider the difference between clients in terms of the potential impact of any assistance provided. It's important to say here that triage on the basis of likely outcomes requires the ability to predict or at least anticipate the future outcome with and without the available assistance. And this will depend on appropriate and comprehensive information being provided at intake and the triage officer being able to effectively apply this information in the client's particular situation and circumstance. So this will require the triage officer to have a high level of legal skills. So depending upon the pathway and purpose of the triage model, triage may be undertaken by a legal services officer, a generalist lawyer, a specialist lawyer, or a referring non-legal worker. And the capacity to assist at the time of triage will depend upon the match between the skills or the capacity or the role of the triage officer and the legal issues, and also possibly the client's capability. So automated triage or online triage is an area that is seeing quite some development at the moment, and we'll be keeping our eye on that. The value of some discretion in a triage model can't be underestimated, so it's going to be really interesting to see how automated triage tries to account for that. So what might triage look like? So some states seem to be moving towards a centralised triage model where clients call a central information or legal helpline. But even in that context, triage is also done at organisation or service level 2. So subjecting all clients to the same assessment process is an equitable and just approach where demand outstrips supply. An organised client processing system that allows for easy flow of client information is essential. And being aware of those appropriate referral channels, including onward referral and data on availability of services, is really important. So just to summarise once more, triage is used to identify and link target clients with services appropriate to their legal need and capability. It is used to direct limited resources to those most in need or for whom the assistance provides the most benefit. It can also be used to guide or refer non-target clients to other forms of assistance, such as self-help or other legal services. So as we saw on a previous slide, the intake pathway determines who will have contact with the service. So some clients will already be filtered or triaged out. And then onward referral pathways such as self-help or other legal services for appropriate clients will filter out more clients. And in the middle, we use triage tools. So triage tools are the questions that we ask to filter and triage our clients, and they will be specific to the triage model that you use. So effective triage depends on linking clients with appropriate services. So knowing what works for whom is crucial. So the Foundation has done considerable work in this area, and there are several papers on our website that examine this very question. To do this, we're undertaking systematic reviews of evidence to identify what is currently known about what is effective in assisting people to meet their legal needs. And we're conducting evaluations of new projects aimed at assisting people to access the justice system in order to learn new lessons. So please visit our website to learn more. Just Google Law and Justice Foundation. Alternatively, you can also just contact us directly. So the very last slide for me for today is just a brief mention of a very important part of any model development, and that's monitoring and evaluation. So the purpose of monitoring and evaluation is to learn from your experiences to improve practice and activities in the future. Monitoring and evaluation does not have to be complex or complicated process, but it is invaluable for identifying barriers and facilitators and which approaches work or don't work and why. The benefit for the sector is that we can learn from each other. So the Foundation is continuing to work in this space and we endeavour to share all of our learnings. So drop by our website every now and then to see what we've been up to. Alternatively, as I said, you're very welcome to reach out to us directly. And that's my presentation. I will hand over to Katrina, who is going to be talking about a telephone line service.
Thank you, Karen. I'm Katrina, and I'd like to start by acknowledging the traditional owners of the land from which I join you today, the Camaragal people, and pay my respects to elders past, present, and emerging. And thank you to Sammy for inviting us to present on the Foundation's work today. Now, in my presentation, I'm first going to cover the why and the how of the research, and then focus on the implications of the findings for legal information services more generally. So first of all, why we did this research. The research was funded by Victoria Legal Aid, VLA, under our Research Alliance, and this alliance was set up in 2015 to support work of mutual interest. VLA were keen to give strategic consideration to the role of information services within their wider offering, following the Victorian Government's 2018 review of access to justice. And this recommended that VLA become the primary entry point for information about legal issues for the entire Victorian community. We initially conducted a literature scan, ran workshops and staff surveys to develop a programme logic which was intended to encompass all VLA's information services, which in practice are delivered through multiple channels, including their website, web chat, CLE events, CLE resources, and telephone. And that initial work that you undertook identified that legal information services are a relatively under-researched area, particularly in terms of understanding their role in their client pathway and what such a low-intensity intervention can achieve for clients. So with VLA's assistance, we designed a research project to identify the value of information services to clients using the particular example of clients of VLA's telephone service, Legal Help. Now, VLA Legal Help is essentially a call centre arrangement. It's based in VLA's head office in Melbourne. Its telephone lines are accessed using a 1300 number. It was 8 AM to 6 PM during the research, but I see it's restricted hours 9 to 5 currently. The service combines a triage role with information and referral for clients that don't qualify for VLA's more intensive services. So clients that meet the criteria, having in-scope legal problems, belonging to specified priority client groups, having access to any moderate financial resources, they can qualify for personalised legal advice, either by transfer to a lawyer within Legal Help or elsewhere within VLA. Now, this particular research that I'm talking about today did not directly assess this aspect of the triage role because it excludes those that were triaged to more intensive services during the call. The clients included in this research were those that only received information or referral during their call to Legal Help. But that doesn't mean that they did not go on to receive more intensive services from VLA or for another not-for-profit or indeed from a private lawyer. It is not therefore an assessment of the impact of only receiving information services. So unlike other VLA clients, there's no identifying information routinely collected about information and referral clients. So we had to set in place an ad hoc data collection arrangement to collect client characteristics, description of what they were calling about, details of the referral and information that were provided to them, and their contact details. And contact details were only collected if the client had consented to having their details passed on to us. And we also at that point took the opportunity to include a few questions for the member of staff to record their own experience of the call. Now, about a week after the client's call to legal help, our small team of researchers attempted to make contact with the client by telephone, offering a $30 gift token for participation. 111 clients were interviewed by us over the phone, and at the conclusion of this interview, we asked if we could contact them again in 3 months' time. The 3 month interviews were 80% self-completion online and 20% by phone, and a further $30 gift token was provided to those that participated, but even so, we could only persuade 85 of the 111 to undertake that second interview. Now, by randomly selecting respondents from that initial client recruitment form that the staff filled in, and by making multiple attempts to contact selected clients, our aim was to achieve a sample that was representative of all legal help clients so that the findings could be generalized to all clients. However, even so, at 111 clients, the sample is too small for statistically robust findings. And it's also our view that the sample is probably not fully representative of all clients in practice, as firstly, not everyone who was asked agreed to participate, and perhaps more importantly, not all legal help clients were actually asked by the member of staff whether they wanted to participate. And then we luckily recorded why that was, and the two main reasons, well, not luckily, obviously, it was our sheer expertise to knowing how to do these things, that the key problem was that the nature of the call was too difficult. So I think it's important to bear in mind that the findings are probably biased towards clients who had a better experience during that call. Now, according to the program logic that we devised, the purpose of VLA's information services is to provide Victorians with reliable, targeted and timely legal information that meets their diverse needs, interests and capabilities. And recognising this diversity of needs and capabilities, separate goals were identified for lower capability clients and higher capability clients. And I think at the design stage, really we had an assumption that low capability clients would be triaged to more intensive services and so didn't need to be a focus of this research. But we did include measures of capability in our survey, and it soon became apparent that there were many clients who in practice would struggle to self-help in our sample. And some of the most interesting findings do relate to the differential experience of the service by levels of capability. Now, the reason that there are low capability clients is that a number of possible reasons. The first is that they called about a legal problem type that was out of scope for legal aid assistance. The second possibility is they didn't meet VLA's definition to be triaged to advice services or elsewhere in VLA. Or thirdly, they were triaged to more intensive services, but that was going to be provided at a later date. Now, when designing this research, we identified 6 domains of value for legal help, which covered the immediate, medium-term and longer-term impact of the service on clients. And the full report considers how legal help measures up against each of these. But today, I'm just going to focus on 2 questions. What do we learn about the features of telephone information service that make it work for clients? And what do we learn about the challenges for information services more broadly? So just summarising the 100+ page report, I can conclude that legal help does provide value to clients on all the domains that we assessed. And from our research and observation, there appear to be 3 main reasons for this success. First, the legal aid brand and what legal help actually provides to clients. Second, the quality of the staff at legal help. And third, the quality of the resources available to those staff. So the recognition of the legal aid brand and the positive associations with the name are hugely valuable in reaching clients. There are some relevant quotes from clients shown on this slide. Now, a lot of people call legal help, at over 15,000 calls during the 10-week research period. And importantly, 3/4 hadn't called before, suggesting a reasonably good level of awareness amongst the Victorian community. And when we asked why was it legal help that you contacted, the financial reasons was the most often cited reason, even by those that went on to pay for private lawyers. It was also clear that legal aid is trusted, perceived as approachable and accessible. Most of the surveyed clients recognise that the service is open to all Victorians. And the resulting client profile reflects what we know about who experiences legal problems. It has a younger age profile than the population. Clients are more likely to reside in disadvantaged areas, and it's also relatively culturally diverse. And clients are not calling about trivial problems. More than half said that their legal problem was having a severe impact on their life, and 9 in 10 that it was having at least a moderate impact. The staff work in small teams and have physical proximity to a team head, or they did pre-COVID when we did our observations. And each team is designated 1 or 2 lawyers that are available to consult in person during the call by putting the client on hold. And there are also a number of staff who can take calls in a language other than English. And what was very apparent from listening into the calls and from the client survey responses was the quality of the interactions. Staff are so pleasant and calm, and respectfully probe for details of the legal problem. And this chart on the screen shows the rating of the clients 1 week after their call to legal help, with almost all saying they were treated with respect, and that the staff member understood their problem well, and over 8 in 10 said that the person they spoke to was sympathetic. A minority said they found it hard to understand what they were told, and or they felt rushed by the person they spoke to. And the quarter saying they had other questions they would have liked to have asked but didn't is perhaps a little concerning, but on the other hand, 2/3 completely disagreed with that view. The third reason that legal help delivers a quality product to clients, from our observations at the call centre, is that staff have access to an impressive set of resources with clearly documented procedures and pathways to follow for clients. Triage is mainly done using online tools. As I mentioned, staff can transfer clients that qualify for advice services to a legal help lawyer for immediate assistance, or they can book appointments with legal help and elsewhere in VLA. And the information they can provide over the phone is backed up by tailored information emails that they can construct for each client during the call. They can also text referral information direct to a client's mobile phone. And as the last slide showed, the information they provided to clients was generally viewed as helpful. Okay, so that's the good news, but nice as it is to report the wonderful work a service is doing, the real value from research is in identifying those small imperfections and encouraging a conversation about the challenges, 6 of which I've identified here. Now, the first challenge, of course, is that telephone information services are necessarily reactive unless they're proactively making calls to prospective clients or undertaking some form of outreach. And while I'm sure the audience that I'm talking to today all understand the concept of the legal need gap, that is between the number of people who have a legal problem and those that seek assistance for it, I've included it here because at the foundation we do still hear the assumption made that the number of clients receiving services is a good indication of the extent of legal need. In practice then, reactive services are ideally supplemented by proactive services and other mechanisms that can narrow this legal need gap. The second challenge we identified is the sheer range of legal matter types that clients call about. There are 345 different types recorded during the 10-week research period. And in addition, matters may range in complexity and have non-legal aspects, such as clients who are at risk of violence, of homelessness, that demonstrated mental health issues, or indicators of drug and alcohol dependency. The quality tools and procedures that legal help has and the support of lawyers from across VLA are necessary to manage its diversity of need, but this is also where access to a comprehensive external offering of other referral organisations, legal and non-legal, is absolutely crucial. The third challenge that an information service available to the entire community faces is the range and capability of callers. About half the clients in our research we classified as low capability because they had 2 or more indicators of vulnerability to the impact of legal problems, such as poorer English language skills, lower educational attainment, limited technological competence, and health issues or limiting financial circumstances. Now, this chart on the screen is the same one I showed earlier, but now it's disaggregated by the number of those client vulnerabilities. So those who reported none of the other vulnerabilities are the dark blue line on the chart, whereas those reported 3 or more in our survey are the orange bar. And although the quality of the experience provided by staff doesn't appear to differ very much, it's the client's assessment of the value of the call that deteriorates with increasing vulnerabilities. The most vulnerable are the least likely to say the information was helpful. They're the most likely to say it was hard to understand what they were told, they felt rushed, and they had other questions that they would like to have asked. Now, we also asked the legal help staff how they thought the client had experienced the call. And staff clearly recognised that some clients were harder to understand, had needs that were harder to meet, or struggled to understand what they were told. And while this was clearly an issue for clients with the lowest levels of educational attainment, which are the paler blue bars on this chart, it was also the case for the clients with the highest levels of educational attainment, the darker blue bars. Now, we can only hypothesize as to why this might be, but drawing on findings to questions about what clients were seeking when they called legal help, we can see that there are challenges in meeting the needs of either end of the capability spectrum. At the high capability end, callers are articulate and demanding. They've often visited VLA's website, they found the information there too generic, and now what they're seeking is personalised advice tailored to their own personal circumstances, and they don't qualify for it. At the low capability end are the clients with poorer English skills, lower educational attainment, they haven't prepared for the call, they don't have the paperwork to hand, and they're short of time. And these clients are most likely to talk about wanting to delegate next steps. They're looking for a personalised assistance and representation. And remember, during the call to legal help, the ones included in our research only received generic information or referral. The fourth challenge we've identified is the incentive to be helpful, to keep the client happy by providing something tangible, such as a referral or information email. Providing direction to next steps can also be a useful technique to end a protracted call. And although we didn't see any evidence of this, potentially referrals could also be used to shift responsibility for conveying bad news onto other organisations. Almost none of the clients in our sample received nothing at all from legal help, because even that small number of clients on the chart that had no referral, half of those received an information email instead. So referrals were used universally, and there was no evidence they were used differentially according to the capability of the client. However, it is possible there was an increased use of warm referrals for lower capability clients, as I'll show you on the next slide. Now, the clients themselves generally like getting multiple referrals as it gives them various options to pursue and perhaps increases the chance of finding someone to help them. But previous research has indicated that client willingness to follow up on referrals and perseverance does decrease with the increasing number of referrals, which does bring me on to the referral merry-go-round. So first, the good news. The information a referral provider clearly empowered a substantial proportion of clients, particularly the more capable, the darker blue bars. As expected, the least capable were less likely to have undertaken some kind of self-help action and were generally less likely to have taken some proactive action overall. Now, some of those waiting to be contacted could have been more warm referrals, but remember, this is now a week or so after that initial call to legal help. Well, what struck us, and it seems surprising, how few clients had taken the information provided to them during the call to decide that the best course of action for them was to take no further action. We did not attempt to make any assessment of a client's chance of achieving the outcome they were looking for, And doing nothing obviously isn't always feasible depending on the nature of the issue, but we were still surprised how tiny this number was. And it did strike us that there is a risk of a referral merry-go-round that is hard for the client to know when to get off, due to this almost universal provisional referral to another organisation. And certainly many of the clients in our research were still pursuing matters 3 months later. At that point, only 42% of clients said their problem had completely resolved. And of those that had ongoing problems, 3/4 said they were still trying to actively do something about it. Now, though most clients benefit from an immediate boost in confidence and feel empowered on next steps, the value of the information and/or referral does decline over time as clients encounter barriers to problem resolution, including disappointment about what can and is provided by the services they're referred on to. So it's not surprising that the initial ratings of legal help did decline over the 3 months. Although even so, 2/3 still said the information had helped them understand their options and made them feel more confident about what to do next. Now, the final challenge that we identified was resourcing. So the information on legal procedures that staff can draw on during the call and the details of other organisations to refer clients to and the information they can package together into those targeted information or emails, all that requires a substantial resource input to develop and maintain. We noted that legal help made relatively little use of non-legal referral, and we recognise that this wider scope of information is even more challenging to develop and maintain. And keeping that referral information up to date is crucial because even the smallest mistakes, unfortunately, such as inappropriate referrals and information that doesn't cover the individual circumstances, there are a couple of quotes on the screen there, have an impact on clients' motivation and direction in continuing to manage their problem. But in the case of legal help, this was an issue for a small minority only. Clients' experience of the service was almost universally positive. And although that perceived value falls over time when problems remain unresolved or end badly, clients' evaluation of the service overall were still high at that 3-month point. As a final remark, because we often get asked this question, it's our view that although technology can supplement telephone services, it's not yet sufficiently developed to replace it, particularly for lower capability clients. And this table is just some additional findings which divide our sample into the lower income, which was defined in our research as under $52,000 a year, and over $52,000 a year. And as you can see there, a clear technological divide in terms of frequency of internet use and confidence in identifying reliable information online. So if you have some spare time, the full report is on our website, as Karen said, along with many other interesting foundation research reports, of course. Thank you all very much for listening, and we're open to questions.
Thank you both so much, Karen and Katrina. I do have a couple of questions that have come through, and thank you to everybody who has stayed on the line. Number one, probably more closely related to Karen. Does the research touch on whether there's a benefit to having legally trained frontline triage as opposed to having a more traditional admin role doing triage?
Thank you for that. That's actually something we haven't looked at in that particular study. Katrina, I don't know if that you didn't look at the triage at all in the law informed.
It wasn't a focus of the research, but it's a really interesting question, and we did record whether the member of staff was a lawyer or not. So it is something we could potentially go back and look at. So thank you for that question.
Excellent, thank you very much. Probably again, Karen, sorry Katrina, but I have another one. Can you give us a bit of an overview about the difference between what you mean by triage and what is typically called demand management on a broader scale?
Let me think. Demand management. I haven't actually come across that term under the project that we were looking at, so I'd want to be sure that I was looking at the exact same definition, and I might be able to tell you what the difference is. Let me have a look. Katrina, have you got anything off the top of your head?
So I guess in terms of demand, is this assuming that that this is people that are turning up at your door essentially, and then the triage is what you do to manage that demand? To be honest, we tend to avoid the word demand because it has that proactive connotation. But obviously we recognise in practice that services do have too many clients to provide all the intensity of services that they would like to.
Absolutely. I think we can all agree that we could do more with more. The next question, did the research, probably out to both of you, did the research look at the needs of people with a disability? That's from Jane.
I'll leave that one for you, Katrina.
We did have questions about disabilities and chronic health conditions. There were so many things we could have looked at, so they were bundled up within that count of vulnerabilities. So if you had a restricting disability, you would have been counted as having one or more vulnerabilities. Again, that we couldn't look at everything, but we could look at that because we do have the data. So another interesting idea.
And this one is from Roxanne. With the study, were clients informed that the staff member only had X amount of time to assist them, for example, a 20-minute time slot, or was it more flexible in terms of the time the staff member spent on client assisting them with their issues?
So I'll answer that for legal help. I did observations for a few days, and although there, you can see how many people are waiting on the line. So there is that kind of external pressure, but I didn't see it in terms of the calls. I saw the client being given the time that they needed. The professionalism of the staff, is just so impressive. How they manage often clients who are not very coherent about what the nature of their problem is, and they take their time to probe through it and find out what paperwork they have, what options they've already pursued, and then give them the time. As I said, they'll put them on call and go off and talk to a lawyer and then come back. So the length of the call, some of them could be very long indeed. So although there kind of is a pressure because they can see how many people are waiting, it didn't seem to factor through in terms of any pressure on the individual staff officer to only spend a certain amount of time with each client.
Sure. And during your time looking at this particular research piece, were interpreters used on the line?
They have, so they weren't counted for our research if the interview wasn't, if the legal help advice wasn't provided in English or information. So there were a number of calls that were conducted in other languages, but they weren't asked whether they wanted to participate in the research.
Sure. Okay. And the next question is from, oh, sorry, you continue.
No, I was only going to say it's not we didn't think they were an important group. It would just that we thought it would have to be a specifically designed piece of research where we also had the facility to conduct interviews in different languages and ensure we could conduct culturally appropriate interviews, and we didn't have those resources available for this piece of research.
That's a really good point. The next question is from Julie. What conclusion, if there's any, can you draw between the discussion on triage and then finding about telephone help? So what are the conclusions between the two presentations? Is there any And has that been part of your research, or will it be in the future?
Well, because you invited us to do this, Karen and I have been talking about what the links are between the two pieces of work, and we're keen to pursue them further and think about that more system triage role that legal help has in terms of identifying where clients should be triaged out to external organisations. Karen, do you want to add something?
No. No, but yeah, this has been a great opportunity for us to actually have a look and see where the links are. And we're going to be developing more on this triage paper. So we'll be looking at the role that telephone-based services will have in that triage.
Yeah, everything is in, with hindsight, you do things differently and ask different questions. It's just the nature of research. But triage wasn't a focus of what we were asked to do for the VLA project initially. But when you look back on it with that triage perspective, I can see there are different ways to analyse the data that might shed further light on what works for what clients in what circumstances. So we definitely want to pursue this work a little further.
Excellent. That's certainly what we like to hear. I think we've certainly got some people who will be having a look at a couple of the reports. I guess we as CLCQ are undertaking a statewide demand management type project that does look at intake and triage as a subset of that, and looking at the ways in which we can help our organisations and our members to do this work in a more holistic kind of way, because we do understand that the community sector is consistently struggling with more influx of demand, or more clients than we have the resources to be able to assist, and that there is certainly an increase in the level of complexity in the legal needs that we are seeing come through our doors post-COVID and even pre-COVID. So COVID is certainly not helping these situations, and so we're keen to be able to empower our centres to be able to do this work in a really meaningful way. As part of your research, I've just had a question come through. Are there any best practice scripts or anything like that that can be shared? I think at CLCQ we are collating some of those sorts of things so that we can put together a bit of a toolkit for organisations, and we can certainly share them back your way if you'd like as well. But was there anything in particular that you came up across that you thought would be useful for organisations to use?
I haven't come across anything that's generic.
We've seen various examples, but what we haven't seen is any good evaluations. And it becomes a bit self-confirming, because whoever you triage on then becomes your client. And we're a little concerned about the way that as criteria might be used, yes, based on the research, but it depends what questions that research asks. So, for instance, a lot of the triage tools that are developed in New South Wales draw on the findings from the Foundation's law survey, but there are questions in there that weren't asked. So one of the key findings we found from the VLA research was that a predictor of poorer outcomes was how chronic the problem had become, how long it had been going on for, but that wasn't a question included in their triage because the law survey didn't ask how long a problem had been going on for. So there are dangers, I think, in how different triage tools are developed unless they are very carefully evaluated. And again, that would be something that we would be interested in doing. So we'd love to see some examples and think about that further.
Sure. Absolutely. Look, we're keen to be able to share whatever it is that we do find. The first phase of our project is running until October, and there are a number of other centres within our membership who are also starting to look at this work. If you are interested, we will certainly send back whatever it is that we find, and we'll keep in touch with you. And thank you so much for all of your time and for the time leading up to this. There's a lot of work that goes behind the scenes, and we certainly appreciate your expertise and you being so open and willing to share. We don't have any more questions coming through at the moment. Thank you very much for everybody for staying on the line and for asking such thoughtful questions. And of course, once again, thank you to Trina, thank you to Karen for everything that you've done for us. We certainly really appreciate it. And if there are any other questions that come through, I might circle them back to you so that we can help people who do have any specific or more burning questions, if that's okay.
Yes, of course.
Wonderful. Thank you very much, everybody. Have an amazing afternoon. I will circulate the webinar recording once it's all ready to go, and have a great day.
Thank you.
Thanks, Sally.
Thanks. Bye, everyone.